All right. Well, good afternoon and welcome to the Environmental Law Institute's webinar, Judging in a Changing Climate, Lessons from Water Courts. We are so delighted that you are joining us today for this important session. My name is Madison Calhoun and I'm the Senior Manager of Educational Programs here at ELI. I want to take a moment to thank all of our incredible speakers for joining us today. We are so grateful for their time and energy preparing this content for you. Full speaker biographies are posted on our website at eli.org. I have just a couple quick housekeeping notes for you before we get started. First, we will conclude today's program with a Q&A session. However, we encourage you to ask your questions as soon as you think of them in the Q&A box on Zoom. You don't have to wait until the end to ask them. Additionally, if you have any tech issues, please feel free to send a message to me in the chat or email me at calhoun@eli.org. And now I'd like to briefly introduce the moderator of our session, Sandra Nichols Tyam. Sandy serves as the Associate Vice President of Research and Policy at ELI, as well as the Director of our Judicial Education Program. Sandy is an attorney specialized in developing and implementing effective legal and policy approaches to solve sustainable development challenges. I'm going to go ahead and turn things over to you, Sandy. Thank you so much, everyone.
Thank you, Madison, and thank you for your help pulling together this program. I want to start by thanking my team, my co-director and founder of the Climate Judiciary Project, Paul Hanley, our colleagues Sarah Roth, John Doherty, and especially Jared Page, our staff attorney and curriculum editor, who really made this program come together. As long predicted by climate scientists seeking to understand the dynamics and impacts of our changing climate, many climate impacts are steadily becoming a daily reality across the United States and around the world. In particular, drought conditions are pressing in much of our country due to decreased snowpack in our forests, decreased summer precipitation, and increased temperatures. As of the end of November, close to 50% of the territory of the lower 48 states was in drought, and 50% of the 50% of the whole US territory and 60% of the lower 48 states were in drought. This affects 370 million acres of crops and approximately 132 million people. These conditions have many impacts on society and ecosystems, but there's no way in which this shift is clearer than in the decisions that have to be made about who gets to use water from a given water body for what purpose. The Western United States has long been seeking to manage these competing demands. Each state has established a unique system to balance the needs and rights of farmers, metropolises, small communities, including tribal and environmental justice communities, ecosystems, hydropower, and other water users. Demand increasingly exceeds its supply, and how to equitably, in the face of past and present inequities, allocate this water supply is increasingly challenging. These decisions fall to regulatory, administrative, and judicial bodies to resolve in the context of a complex and almost arcane legacy tangle of legislative, regulatory, and equitable rights, agreements, allocations, and the particular structure of the adjudication of such rights, which is different in each state, as you'll hear today. To give an idea of how complex these are, some water allocation disputes have stretched on for almost 100 years. All of these legal authorities, substantive and procedural, and institutional structures must be navigated in the face of the growing shortages and our current, much more sophisticated understanding of hydrology. The idea for this seminar came out of our conversations with Judge Arrieta about his experience as a water court judge in New Mexico, and with others through the Climate Judiciary Project, and in particular, our collaboration with the National Judicial College on our Judicial Leaders in Climate Science program. Another leader in that program, the Honorable Michael DeRita, also from Utah, helped contribute ideas to this program. ELI's Climate Judiciary Project is building a network of judges and scientists meeting the judiciary's need for basic familiarity with current climate science and to keep pace with climate issues emerging in courtrooms and the law. CJP conducts education programs, produces curriculum materials and online resources, and delivers presentations and seminars. To date, the project has provided training to hundreds of state and federal judges and is continually building our network of leaders in this space. The challenges presented by climate change are vast, and we need the vision of real leaders and true leadership to successfully respond to these challenges. So we are thrilled to have with us today a leading expert and two outstanding judicial leaders who have been leading the way towards how courts can better handle water allocation and water issues in the face of the changing climate. Before I turn to introducing the speakers, I just wanted to mention that each of these discussions about how courts can prepare for the new trends in climate litigation, and even specifically how the role for specialized courts or other resources, each conversation leads to related questions and possible ways forward. So we decided as in developing this webinar that this should be the first of a series of webinars focusing on court structure and judicial resources for preparing the judiciary for climate change. We're working on developing the next webinar, potentially on scientific support for judges, such as independent judicial experts, specially trained court neutrals or special masters, or other approaches. We hope the discussion at the end of this session can help inform future topics for webinars. Now, let me turn to introducing our speakers. I'm delighted to have with us John Thorson. He is a native of New Mexico, and he serves as the federal water master for the Lumi Decree. He has lived and practiced law in Arizona, California, Montana, and New Mexico. His legal career has focused on water law and policy with an emphasis on general stream adjudications, federal and tribal water rights, interstate litigation, and alternative dispute resolution. In addition to private practice and law school teaching, John has served as a special master for the Arizona General Stream Adjudication, assistant chief judge for the California Public Utilities Commission, and chair of the congressionally chartered Missouri River Recovery Implementation Committee. Next, we'll have our colleague, the Honorable Manuel Arrieta. Judge Arrieta is a district judge sitting with the 3rd Judicial District Court for the state of New Mexico in Las Cruces, New Mexico. Judge Arrieta was appointed in 2012 as the water law judge for the district, which encompasses the Lower Rio Grande District. Judge Arrieta is a graduate of New Mexico State University and the University of Michigan School of Law. He is a true leader in advancing ideas to prepare the judiciary for the litigation coming as a result of climate change. And finally, we are honored to have with us today Judge Mary Kate Appleby. Judge Appleby is an active senior judge. She was appointed to the Utah Court of Appeals in September 2014. Prior to Judge Appleby's appointment, she was a 3rd District Court judge for nearly 8 years. Judge Appleby graduated from the University of Maryland in 1991 and has spent her early law career there. Judge Appleby currently serves as a member of the Judicial Council. She's a fellow of the American Bar Association and, importantly, a convener of Dividing the Waters, a network offering resources for judges resolving water law conflicts. The exciting developments in Utah that we'll hear about today come from Judge Appleby's vision. As a trial judge, she observed the inconsistencies that arose when water law cases were given to judges across the state, and the challenges that each of those judges faced in coming up to speed on this complex area of law and science. I look forward to hearing from her today about how the new system is working. So without further ado, I will pass the metaphorical mic over to John. Thank you so much.
Thank you, Sandy. I'm pleased that ELI has turned to water law for lessons about how specialized courts and tribunals, many already functioning, how they might be adapted for litigating and resolving climate change cases. I'm also pleased to share this session with Judge Appleby, who I've known for some years, and Judge Arrieta, who I met just last week. My interest in water courts and similar tribunals dates from my work in the stream adjudications, those comprehensive and complex determinations of state and federal rights pending throughout the American West, some for more than a century. Some of these proceedings have been in state court, others in federal. Some have been before general jurisdiction judges, and at the other extreme, others before dedicated water courts. As these adjudications are completed, water law expertise and hard-earned dispute resolution infrastructure face dissipation. More often, Western state water professionals are debating the possible utility of permanent water courts in preserving these experiences and expertise. In the time available to me, I'll briefly describe the range of adjudicatory institutions and procedures available to bring scientific and other technical and legal expertise to complex water and environmental law cases. I'll start with the wellspring of specialized water courts, the water tribunals of the Iberian Peninsula. I'll then move to experiences in the American West, followed by mention of some non-water specialization methods and a description of a leading international model, the New South Wales Land and Environment Court. Finally, I'll list some of the criteria that should be addressed when considering such specialized forums. Hopefully, these various approaches will provide ideas for adjudicating climate change cases. The Spanish Iberian Peninsula is the setting for a variety of water tribunals dating from medieval times. Judge Arrieta had the opportunity recently to visit the region. The irrigation systems were built during the Andalusian era, the 9th to 13th centuries, and they divert water from the Segura and Turia rivers for small farm irrigation in this fertile area near the Mediterranean. The Council of Good Men and the Tribunal of Waters are the leading examples of these institutions. Both courts decide irrigation-related disputes among water users. The Council of Good Men serves the irrigated crop-growing region of Murcia. The community of 13,000 farmers irrigates 16,000 hectares of land, frequently small farms and fruit orchards from the river called Seguria. A governing board of 500 members annually elects an administrative entity, the Landowners Board, along with 5 speaking procurers who represent irrigators from the major canals. These 5 speaking procurers, along with the president and secretary of the board, comprise the Council of Good Men, which meets weekly and publicly in the City Hall. The Tribunal of Waters covers the irrigation communities diverting their water from the river Turia. While irrigating less acres, this tribunal operates in a similar fashion. Operating for centuries, these Spanish tribunals constitute as functioning dispute resolution forums in their unique geographic and cultural context. These tribunals demonstrate the utility of a knowledgeable court of arbiters drawn from the local community, informal prompt procedures, modest transaction costs, and full integration into the country's judicial system. The courts sustain the cultural importance of water in the region. Some Spanish approaches to water conflict resolution made their way to the American Southwest in the forms of acequia organizations, many still in existence, particularly in New Mexico, and mayordomos who oversee water distribution at the local level. But with the turn of the 20th century, there was a growing recognition that a more specialized approach should be taken to water management. Resource managers looked to the progressive conservation movement and the scientific management movement to apply science to resource management, including water. This recognition took 2 different approaches, reflected in a tension that persists. Over time, Colorado committed itself to deputizing district court judges in water divisions, assisted by knowledgeable referees, to preside over disputes involving new water uses and transfers. Alternatively, California and Wyoming embraced a more administrative approach, creating a new executive officer, the state engineer, who with a technical background took a leading role in water management and conflict resolution. In the 11 Western states today, 2 states, Wyoming and New Mexico, still have relatively freestanding state engineers. In other states, the state engineer is a position within a larger resource agency, or the role is performed by a DWR director, also within a larger agency. Colorado remains the only state vesting considerable permitting and transfer authority in the court system. These institutional choices do not, in all cases, address one nagging water law problem, the incomplete determination of the ownership of water rights and their characteristics, such as quantity. For a century, Western states have struggled to adjudicate their water rights. I've already mentioned Colorado's Permanent Water Court, a division of the district court. Because the state has practiced ongoing adjudications for over a century, the process is essentially complete for state law rights. However, the district court, in its water court role, reviews both new right applications and transfers that are reflected in updated judicial decrees. Montana is one of two states, the other being Idaho, with long-term water courts established for the purpose of conducting these large general stream adjudications. Montana established its water court in 1979 as part of the judicial branch for the exclusive purpose of conducting the statewide adjudication. The court consists of a chief and an assistant water judge with the same rank as district judges, located at a permanent facility in Bozeman. The judges are assisted by a team of special masters. Idaho commenced its now completed Snake River Basin adjudication in 1987 to determine water rights throughout the entire Snake River system, including groundwater. The case involved 2/3 of the state's irrigated agriculture and over 150,000 claims, including extensive filings by tribes and federal agencies. Using a hybrid system, the state DWR reviewed claims and submitted reports to the specialized water court, presided over by a district judge assigned essentially full-time to the case. Special masters and the judge resolved objections. The court, located in Twin Falls, remains a part of the judicial branch. The final Snake River Basin decree was entered in 2014. But pursuant to a Supreme Court order, the water court continues to hear water-related appeals from state administrative agencies, as well as water cases transferred from other courts. The court is also engaged in smaller adjudications in northern Idaho. Will these water courts exist after their quantification tasks are complete? Colorado's water court is a long-standing feature. Idaho's water court is temporarily permanent, if that makes any sense. And Montana is deliberating the post-adjudication future of its court. But several quasi-judicial entities provide other examples of tribunals addressing issues broader than just water quantity. The Washington Pollution Control Hearings Board is a substantively broad quasi-judicial agency. The board hears appeals against state and local decisions concerning air, water, and forestry. Another quasi-judicial agency is the California State Water Resources Control Board. This board is the culmination of a merger of water right and water quality regulatory programs and serves as a national model of how these traditionally separate fields can be integrated. This board consists of 5 full-time members, with each member filling a certain occupational category such as engineer or lawyer. They are appointed by the governor and approved by the state senate. In addition to water right matters, the board protects water quality by setting statewide policy, coordinating and supporting regional boards, and reviewing appeals against regional board decisions. These courts and tribunals are not the only manner to achieve the benefits of specialization. Let me mention 5 others. Individual judges with expertise. In some courts, the presiding judge may assign cases to a judge with relevant expertise. Federal cases over the years concerning California's Bay Delta and the San Joaquin River were assigned to the same judge in Fresno who developed expertise and detailed knowledge of the issues. A second approach, specialized and trained and assigned judges. California has a specific provision under its Environmental Quality Act requiring the superior courts in certain counties to designate CEQA judges to develop expertise concerning the statute and related land use and environmental laws. The U.S. Foreign Intelligence Surveillance Court is another example. Federal judges from around the country are detailed for multi-year service in reviewing national security warrant requests. A third method, case coordination. Courts have developed or legislatures have provided procedures to facilitate the assignment of complex cases to a certain judge who may have developed expertise over the years. At the federal level, the U.S. Judicial Panel on Multi-District Litigation can coordinate and assign related cases to one judge, even from a different part of the country. This panel was created in 1968 and consists of 7 sitting judges who are appointed by the Chief Justice. Over the years, this panel has considered motions for centralization of 500,000 cases. A similar process is employed in California under the Judicial Council's civil case coordination rules, allowing similar cases pending in numerous superior courts, often water cases, to be heard and decided by one judge. A fourth approach, court-appointed experts. The federal rules of evidence allow a court to appoint its own expert witness, Rule 706, with opportunities for examination by the parties. Similar evidentiary rules are in place in many states. And then finally, judicial education. Even without a major structural change in how water disputes are resolved, judges benefit from improved continuing education concerning water and environmental law. Such educational opportunities are already available through the Dividing the Waters program at the National Judicial College. Since 1992, this program has provided state and federal judges who preside over complex water cases with educational programs on complex case management, ADR, hydrology, scientific evidence and models, and the basics and updates on Western water law. Dividing Waters just completed a major conference in Santa Fe with the topic of the Colorado River Compact, attended by judges from 8 or more Western states. But let's turn to some international tribunals for other methods. The best source of this information is the University of Denver Law School's Environmental Courts and Tribunals study. The ECT study began in 2007, is co-directed by the husband-wife team of George and Catherine Pring. They have documented the judicial entities and administrative tribunals around the world specializing in deciding environmental, resource, land use, and climate change disputes. 1,500 ECTs in 44 countries. Their results are presented in 2 books prepared for the UN Environmental Program and may be found on the University of Denver Law School website. Among the ETCs they reviewed is the New South Wales Land and Environment Court. New South Wales is a state in southeastern Australia extending over 300,000 square miles, roughly twice the size of Montana, with a population of over 8 million people. Prior to 1980, the state had a series of specialized tribunals and courts. At the time, environmental law was essentially non-existent, but parliamentarians decided to create a specialized forum for these cases. The result was the Land and Environment Court Act of 1979, creating the Land and Environment Court. The court has 8 broad areas of original and appellate jurisdiction, appeals from state and local environmental and planning agencies, land condemnation cases, including Aboriginal land claims, criminal proceedings concerning violations of environmental law, and other topics. Although most of the proceedings involve land and environmental matters, the court does hear proceedings under the State Water Management Act and Threatened Species Conservation Act. The court consists of judges, currently 6, appointed by the state governor, and full-time commissioners, currently 9, and acting commissioners, currently 16, appointed by the court. The acting commissioners need not be attorneys, and the panel includes a diversity of experts in such fields as ecology, anthropology, surveying, and cultural heritage. The chief judge may direct that a commissioner with relevant expertise sit with the judge, or that 2 or more commissioners sit together to hear certain matters. The court's decisions can be appealed to the state's appellate courts and to the High Court of Australia. Many organizational design questions, such as jurisdiction, must be addressed when creating a specialized court or tribunal. The Prings at the University of Denver address them thoroughly in their publications. With my time expiring, I will close by listing 4 fundamental principles I believe must be honored in any initiative. First, sound principled decision-making. This requires that the specialized tribunal produce quality outcomes, admittedly a very difficult result to demonstrate. This consideration raises a contemporary dichotomy. The field of water law is an equal mix of science and engineering on the one hand, and law and public policy on the other. The challenge is to design institutions and recruit adjudicators able to bridge both worlds. A second principle, lawfulness and due process. The components of due process are especially important. Notice, opportunity to participate, comment or respond, and reasoned, unbiased decision-making. The third principle, efficiency. Efficient dispute resolutions require the least amount of time and resources necessary to produce sound results. Because of the routinization of work, administrative agencies may be more efficient than courts, which typically have high transaction costs. However, contested proceedings before administrative agencies are often lengthy and costly as well. The fourth principle, coordination with other water policy programs. Normally, a jurisdiction's water policies and programs should have a considerable degree of coordination. Although specific agencies and courts have unique roles, and some friction among our branches of government is necessary and often positive, we do not want agencies or forums to consistently work at cross purposes. And finally, legitimacy. The decisions of adjudicators should be considered legitimate by the parties and the interested public. With weather and ever-increasing populations and economies, water resource management is emerging as a leading environmental issue of the 21st century. Conflicts and litigation are inevitable, and if wisely resolved, may make the difference between successful or failed adaptation to this new reality. Specialized tribunals and other carefully designed measures may have an important role in this future. Thank you.
Thank you, John. And we'll now turn it over to Judge Arrieta.
All right. Thank you, Sandy. And thank you, John. Good morning, everyone from New Mexico. I'm Judge Manny Arrieta. I want to give you a little bit of background of what I do before I go into my comments here. I am a water law judge here in New Mexico, and I've been one for 12 years. Here in New Mexico, we have a water court structure that has three basic elements. The first element, if you will, is the adjudication court. It's an exclusive court where all of the water rights are permanently determined. And it's one judge who's currently handling a number of adjudications. There's probably half the state's been adjudicated at this point. Takes a long time to get adjudications done. So the second element of our structure is the Office of the State Engineer. The engineer administers and allocates water during the process of adjudication and outside of adjudication. And finally, we have the water court judges. That's the part of the element that I'm involved in, which is basically your trial judges. We're the ones that hear all the appeals from administrative agency. In this case, it would be the state engineer. We also handle a lot of the common law claims as well as equitable claims that are being made. And that is a lot of area to cover for water court judges. I happen to be in the Lower Rio Grande district, which is the busiest district for water judges. All right, that being said, as John indicated earlier, the Western states, including New Mexico, of course, have for centuries been dealing with drought. I am one of the graduates of the program Climate Science Leaders, sponsored by ELI as well as the College of Judicial College. One of the things that I was surprised about is as I sat there in that program, I realized how much of what I do as a water judge is what is occurring and what's being taught in the climate science programs that we were sitting through. A lot of it was very familiar to me. Let me explain that to you. When we talk about the changing climate in courts, what we're really talking about in the Western states is drought. Climate change in the Western states is drought, and drought, of course, is water law for us in the Western states. How do we receive these cases, both climate change type cases as well as water law cases? Well, for most of us, we receive them through appeals from administrative agencies. And even if you're not in the Western state, if you're back east, you probably receive water law cases from administrative appeals. Let's say your Department of Health, an environmental protection type agency, may have Department of Emergency Management. You may have some coastal administrative department to handle, issues coming from hurricanes and rising waters, so on and so forth. So we all basically do, in a sense, climate change cases. They just come through the administrative portion of our state appellate work, appellate work going to the district judges. We also receive a lot of these cases from the common law, be it equitable or be it common law in the sense of negligence cases, both water and climate change cases. We also receive it through public nuisance type of cases, constitutional and public tort, social justice, and the normal water law cases that we receive. 2/3 of my docket, in fact, are common law cases. Not every water case that we receive is going to come through the administrative side of the entity, nor will it be just strictly limited to common law cases. So kind of giving you that background, how do we deal with climate change at the same time with water law? It appears from, what we've discussed at our climate science program that there's sort of two sets of thinking here. Who establishes the water courts or climate science courts? Is it the judiciary or is it the legislature? We're going to have to deal with both of them, especially in the Western states, as one and the same, because as I've said, droughts are climate change. They're also water law cases. By and large, the water courts are generally created by the courts themselves as part of their superintending control rulemaking ability. There are some states that require such ancillary courts as drug courts to be created by the legislature. My review of these cases seems to indicate that for the most part, you're going to create these courts through the superintending control and rulemaking authority of the courts. We can see that in courts like drug courts, family court, there's specialized business courts. Quite often, these are created by the rulemaking authority or superintending control of the courts in your respective states. In my review of who creates these courts, whenever drug courts, for example, are created by a legislature, it's usually by a state that feels that new courts are being created, new judgeships are being created. In New Mexico, we're very fortunate. We created water law courts by rulemaking authority. And this was done in 2004 through an order from the Supreme Court here in New Mexico. That basically established the water judges. And it makes sense because if you establish a water court, or better said, a water division, you're not establishing a new court. You're simply taking these administrative and common law water cases that I've described and funneling them into a certain docket or set of judges. The judges already exist. These cases already exist administratively or by common law. And all we're doing is funneling them into a certain docket. We call that the water court division here in New Mexico. Loosely, we call it the water courts. By the same token, I think that, as I've said earlier, climate science or climate change should be merged into water law because it's one and the same, especially for Western states. This can probably be done through the superintendent control or the rulemaking authority of your local courts. I found in my research there's only one state, I think it's Missouri, that requires, for example, drug courts to be established by the legislature. The problem with establishing anything by the legislature is, as we all know, is two things have to happen. One is there has to be an enactment, and that takes quite some time because of politics. Then secondly, the enactment has to be funded. And, all our state budgets are usually constrained. So it's quite easier, more logical, and more efficient to try and establish your water courts, your climate science courts through superintending control, rulemaking authority of the courts that already have that. And really, it's most of the courts throughout the country. Now, we are in discussions here in New Mexico about merging climate science with our water judges, because that makes sense. Before we do that, we've got to talk about some logistics. We've got to talk about, how things can work out. Do you appeal to the Supreme Court? Keep the appeal with the Court of Appeals? Do you merge certain water judges into one district? Because we found out, and as John sort of talked about, from state to state, and even within a state, the type of water cases that you receive and the way drought affects that region change from one side of the state to another. They change from one state to another. One of the interesting discussions we had here with the Dividing the Waters seminar that's been mentioned is we talked about what is the best water court structure, or not structure, but code, set of laws for those states that sought to bring in water judges and establish the code. And we, I think, came to the realization that there's really not one model code that you can adopt, because every state is different. The geology is different, the hydrology is different, and the politics are different. So we have various different types of water codes, and that's true even within the states itself. So we're still talking New Mexico about how we're going to do this. How can we merge climate science into our water courts? All right, this last part of my comments I want to talk about, once you get the initiative going of establishing a water court, how do you do it? First of all, you should start with providing information to the judges as well as your policy-making leaders about why there is a need for water courts or a climate science court or a merger of both. One of the things that I talk to folks about is when you're discussing this with policymakers, be careful not to talk about climate change, big C. That's the political football that gets kicked around, and that just bogs everything down. So when you talk about climate change, talk about small c, the changes in climate. Those are the observable and objective changes that we all can agree to. The Mississippi River this year dried out in certain places. Lake Mead, Lake Powell are down to 11% because of the drought. There's a 22-year mega drought in the western states, so on and so forth. These are things everybody can agree on. Once we have people concerned and wanting to do something different in terms of water code or water science, then I think we can go to the next step, which is to advocate the need for establishing those water courts or those climate science courts, or a merger of the same. And we need to do it by, of course, educating the courts that would do it by rulemaking authority, or that would do it with a legislative enactment. If we can do it either way, establish water courts, water science courts, the next step would be is educate your judges with the challenges of integrating water code case or water code law with climate science. In New Mexico and other Western states, we have certain tensions. One is, for example, how do you resolve or reconcile appropriation rights with permanent climate change. That's a difficult topic that's being discussed right now. There's not one set of consensus, but we need to educate our judges on how to deal with both water code and climate science changes. We can use a number of tools to do that. One, of course, is the law that we receive at our level of the water judges, which is the appeals for administrative decisions, as well as common law that's already been established, that already deals with drought, that already deal with handling appeals from the Office of State Engineer, using discretion within the body of law. In our courts, in our Office of the State Engineer, I've already seen some discretion being used to allocate water when the amount has diminished, and we're dealing now with the scarce resources separate and apart from appropriation rights. That's one type of tensions. There may be other tensions involved in there. You'll have to look at your specific state, your water codes, your administrative process, and of course the politics within your own respective state. Now, I think I'm getting to the point where I'm pretty much done with my 15 minutes, but folks, if you have any questions about how it occurs at my level, feel free to contact Sandy, ELI. They'll provide you with my phone number, my email. You know, I'll be happy to talk to you about these issues. I think 15 minutes is a hard sort of or short time to really deal with this and address it the way we would like to. Hopefully we'll have some future webinars so we can talk about these little different aspects in more detail. But I'd be happy to answer all your questions. If I can't do it today, my email will be provided to you. Anyway, it's been a pleasure. I hope to talk more water law to you or climate science issues with you. Sandy, thank you very much.
Thank you so much. And as you say, this is one of many conversations that will continue happening in a number of different ways. Judge Appleby.
Morning. Well, I guess it's afternoon where some of you are, but it's morning still here. I'm Kate Appleby of the Utah Court of Appeals. But before I was on the Court of Appeals, as Sandy mentioned, I was a trial court judge. And when I started 16 years ago, one of the first cases I was assigned was a general stream adjudication that began in 1936, which was before my father was born. And I knew nothing about Western water law at the time. And I think any judge receiving one of these cases, the initial reaction is despair. But I was fortunate pretty quickly to be able to find my way to dividing the waters and start getting myself the education and training that I needed. The seminars were very helpful, and I made acquaintances with people like John Thorson. So I had people that I could tap into with questions, but it involved quite a lot of self-study. And back then I started thinking that it might be a good idea to have judges in Utah who had special training in this for dealing with these overwhelmingly large cases that can go on forever. It took a long time for me to gather my thoughts and to reach a position where I could make a proposal. But ultimately, our Judicial Council and our Supreme Court approved a rule designating judges who volunteer for the assignment as water law judges. The rule was adopted last spring. One of the questions that I received back then is, can it be effective immediately? But for various reasons having to do with recruiting the judges to volunteer and getting them trained, the rule officially went into effect on November 1. Nevertheless, we had publicized the availability of this new program starting November 1, and we started getting requests for special assignments well before the rule was effective. But at any rate, it provides for designating volunteer judges as water judges. Why volunteers? Well, I thought it best, and the council agreed, that it would be better not to say, okay, Judge Appleby, you have to do this. We wanted people who were committed and enthusiastic about the project. The rule establishes procedures for designating judges and assigning cases. Some cases automatically qualify for assignment. They are two parts of our water code. So for example, a property dispute involving a well technically touches on water, but it's not really a water law case. So we kept it narrow, partly because we viewed this next year or two as kind of an experiment. Nevertheless, cases outside the automatic qualification can be transferred to a water law judge on motion of the parties, decided either by the judge assigned to the case or by our supervising judge. And experience will tell us whether we need to expand the rule. Our comments suggested that practitioners, both in private practice and from the state engineer's office, would really like it to include the entire code. We do have a designated supervising water judge, and she helps coordinate educational resources. She will help decide whether cases should be transferred to water law judges. She inherited the case that began in 1936, and she now works with a special master to adjudicate that. And I should mention that our special master is also helping adjudicate another big stream here in Utah. Our first challenge, though, once the rule was adopted, was to recruit and begin training trial court judges. And our rule requires that there would be a minimum of 3. And I was worried late last spring, early summer, that we wouldn't even get 3, and then what would happen. But we had immediately 11 people volunteer, and at this point we have 10 people who are designated to do this. There's a range of experience among these judges. So our supervising water judge has a great deal of experience. And then we have some judges who are basically new to the bench and have never had a water case, but they're interested in the science of it. And I think that the motivation that comes from that interest will help fill the gaps. We also needed to, and along the lines of how many judges, it seemed to me that we really don't want 20 or 30. For one thing, that would be almost half our judiciary. But for another, it seems to me that if we were going to develop the depth of knowledge that we want, having fewer judges doing more cases would get more experience to that cadre of judges. So the next big hurdle was to immediately get trainings in place. And we began at our annual conference in September with an academician who could talk both about science and the law. We have more training this week just for those judges, and then more training at the district court conference next spring. Our district court is our trial court. The judges' decisions can be posted on the website if the judge deems the case of sufficient importance that it would be helpful to others. We've also provided the judges with educational resources that are available online through a list of webinars and then a list of books and readings for self-study. I should mention that venue can be outside any given judge's district, so that a judge assigned to a general stream adjudication can do the entire area without worrying about the boundaries. And that way you don't have one judge, doing an upper drainage and another judge doing the same drainage, but on the lower part of it. We're also offering case breaks to these judges so that they don't get overwhelmed from their general jurisdiction dockets, which will be ongoing by these water cases. The thing is that the demands on time from a water adjudication are intermittent, so it might be really intense for a while, and then it might be dormant. So we thought that case breaks would be appropriate, but the judge will work with the presiding judge of the district as well as the district court administrator to determine what sort of break would be appropriate and for how long. We'll know a lot more in a year, but what I wanted to mention is that we have 85 active water law cases pending right now in Utah. And some of those have calendar dates. We have many, many more that are in their dormant phases. But as I mentioned, even before this rule went into effect, we had requests to assign the cases to water judges. And our supervising judge went ahead and approved it. Why not? And we'll just see over time, whether we get people who decide to stick with the judge that they were originally assigned, or whether they would like it transferred to a judge with the special training. Now, as for training, I also wanted to mention that as robust as we hope what we're going to be providing our folks in state, it's not going to be enough. Just a quarterly gathering and self-study will not be enough. And the Dividing the Water conferences are terrific. I benefited from them beginning when I started as a trial court judge, and benefited from the one I attended last week. And Dividing the Waters also does some webinars, which are available through the NJC website. You can watch them synchronously or asynchronously. And we've prepared a bench book on general or stream adjudications. Anyway, look for that. You can download it for free if you become a member of Dividing the Waters, but they don't fully cover the need. Our conferences, the intervals are too far apart. The one we planned in 2020 didn't happen at all because of the pandemic, but usually they're 18 to 24 months apart. They're also expensive, both time and money commitments. So for example, the fantastic one that we had in Santa Fe last week, only 3 of our 10 water law judges were able to attend, either because of the expense or because too much time away from their calendar. So we have begun to explore and develop an online on-demand curriculum that is broken down into modules that will help solve the time and distance barriers of in-person trainings. And it's a partnership between Dividing the Waters, National Judicial College, and SUU, plus we hope Utah's courts. We had a committee of conveners, including John Thorson, work to develop an online curriculum outline. It needs some refinement, but it's pretty comprehensive. And the first module will begin with hydrology and science. But if we are able to fully build it, it will encompass much, much more. We, for example, anticipate modules addressing the specifics of each Western state, both its hydrology and its law. And of course, I anticipate a climate change component. NJC and SUU have agreed to support this. I have recently requested funding from the Utah courts, and we'll see. I'll know the answer to that fairly soon. The production will be professional. Again, nothing wrong with a webinar like this, but if it's something that a judge might turn to, at 10 o'clock the night before going into court, and you need to have a refresher on hydrology, it needs to be more than simply a lecture. And so it would be curated, indexed. Judges could get quickly to what they need to know. So if this comes together, we would have a sort of immediate hydrology science component that would be available. If we're able to realize the big picture, it will be much, much bigger than this. And so I'm really excited about it. It's cutting edge, and we are looking for collaborative solutions among the states. I think it will be the way for us to build a much bigger program. So I'm enthusiastic, and I would also be happy to answer questions through emails and talk to you about how you might like to participate in the exciting developments here in Utah.
Thank you so much, Judge Appleby. We look forward to hearing how your experience develops. We've got a whole bunch of interesting questions here. So let me kick off the discussion. Let's see. Let's start with a question about how it works. Part of the question is when there are crossover between various jurisdictions, who or how is it determined which trial court will preside over the proceedings? And the related question is, can you touch on the sort of pros and cons of New Mexico's jurisdiction for its water judges is very broad compared to the much more defined jurisdiction with some flexibility that Judge Appleby described for Utah. So can you touch on some of those jurisdiction questions with regard to these specialized judges?
So let me start with that, that the assignments right now are randomly made. We've been doing that with our tax judges. And so a given judge might get several of these and another volunteer might not get any. Because each one, and it's, I think, done by computer now, but with our tax judges, it was literally pulling a name out of a hat. I've seen the hat. Right now it's just randomly done. And then as for, the respective benefits of bigger or smaller, I don't know, as I mentioned, our commenters would like to see it expanded. And if I can see that happening and I can see the value of doing it, I just thought start modestly with something that's doable. But we may well end up like New Mexico before long.
Judge Arrieta, do you want to comment on the strengths and weaknesses of such a broad jurisdiction that you and other water judges have?
Sure. We've got a broad jurisdiction in that we're the 5th largest state in the union, but our water code and structure is pretty comprehensive. As I say, we have the 3 elements, which is adjudications, that is exclusive to declaring a basin. You do a hydrological study, you bring all the claimants to determine, who has the senior rights and who follows. That's really a small niche of what we do because, as Judge Appleby indicated, we have some adjudications that have taken decades to complete. And that's all they're doing is they're inventorying who's got the senior rights. Then we have the Office of State Engineer, which does all of the administering and allocating of rights. All the water in New Mexico is public, and to use water, you have to have a permit. And that's what the state engineer does, administratively determines, who gets what water, are there any violations of the code, how should it be allocated during periods of drought. Now, if there's any appeal from that, you go to the 3rd element, which is the district court judges, us, and we handle the appeals again from the Office of State Engineer. We also handle common law claims. Now, although we're a big state, we are divided into 13 districts. Each district has a water judge, and we handle whatever dispute arises in our own district. And that's by the Constitution as well as rule that was created in 2004 establishing water judges. So the only cases I'm going to hear is in Diana County. That's my district, which is the Lower Rio Grande. We may have other folks in outlying districts. For example, on the east side, it's just plains. There's no water in terms of a river. There's no mountains. And all they deal with is underground waters. By the way, New Mexico, we deal with both underground waters and surface waters. And so each district has a water judge, and they all handle their own issues in those respective districts. So it's pretty comprehensive. Every water claim that comes in, whether it's an ownership right for adjudication or whether it's an issue with a competing farmer or someone, those are all going to be heard. And if it's not the adjudication judge, so go to the state engineer or the trial judges, myself. And of course, there's other issues involving jurisdiction and being careful not to go into the adjudication side of it or infringe on the Office of State Engineers authority. That would take probably an hour to talk about. But it's a very comprehensive way that we deal with our water disputes.
Okay, great. There's also a couple of questions about related. Both have talked about this, especially Judge Appleby, but a couple of further questions about specialized education for judges on these issues. So one part of the question is, do you find many judges interested in learning the science, economics, and other issues that relate to water or environmental issues? These are technical areas that can be complicated. And another participant, asked what would be the key starting points for developing a water law curriculum for the education of new water law judges.
Okay, I'll take a stab at that. One is that in recruiting these folks, I tried to emphasize how much it would require. And I had a lot of judges call to say, I know nothing about water law. Why would I want to accept this assignment? And I said, you know, if you're intellectually curious and you care at all about science, as well as the future of our region, this is for you. And so, you know, I'm just counting on people's sort of good faith assessment. And then we picked hydrology as the first online on-demand aspect of our course because of its universal need. So if we're going to have something that would appeal to Western judges in any state and potentially in the East, I mean, I don't know why if you were in Mississippi you wouldn't want to take this. Florida, everybody's got water problems now. It's related to the climate change aspect of things. So we were trying to pick the science foundation that would have the greatest universal appeal with the hope of getting broad support for building out the rest of the program. Some people describe it as a sort of proof of concept that, you know, we would be able to do this and then people would have greater confidence and maybe contribute money, which is what we really need. So we need expertise, of course, but we're also going to need money to do this right.
Great, that's very helpful. And it's interesting that you mentioned Mississippi. Another one of the questions is what have you heard? You know, have any of you heard anything about non-Western, you know, Midwest or even Eastern states starting to think about specialized way of handling water issues in the courts?
John might be a better person to answer that, but I will just say tentatively that the conveners and our subcommittee have long discussed a broader application of what we're doing.
I'll jump in as well. I think there have been quite a few examples of environmental or water-related disputes, particularly at the interstate level in the Midwest and East. Fisheries issue on the Great Lakes, the disputes between Alabama, Georgia, and Florida over the river systems there, groundwater issues involving Mississippi. Most of those have been handled by special masters appointed by the U.S. Supreme Court. I think one challenge facing the Midwest and Eastern states, generally they do not have a good grasp on quantification. And because of the humidity and the moderate conditions historically, that has not been an issue. But as climate change accelerates, I think there may be more disputes concerning who owns what amount of water, and we may see Eastern and Midwestern states look to adjudications as a necessary remedy.
Great, that's really interesting, and it's interesting that that part of the answer was about special masters. There was another question related to that specifically. Do any of you have a sense of how often special masters are used for specialized environmental matters and a perspective on whether that could be useful and how it might play in?
I'm not aware of any special master until recently in Utah. By recently, I mean some years ago. And we've got one, as far as I know, and he's working on 2 stream adjudications right now.
Oh, wow. Okay. Interesting.
I'd like to see more because again, you could sort of develop greater expertise in one person. But it required legislative funding and that sort of thing. And part of the point with our judicial rule was that it was an efficient, low cost, modest beginning. We don't have something like Colorado's water court, which, correct me if I'm wrong, John, I think they promulgated in the 1960s. So it's been in place for a long time with a lot of support, and we needed something now and not go through the legislative effort. And if we were going to add special masters, we would have to get funding for that. So I'd love to see more, but I don't know how realistic it is.
Yeah, maybe I can add a little bit too. I think special masters have an advantage in the sense that they can preside over hearings that the parties are used to, evidentiary hearings. But another alternative, I think, is to look at ADR, getting mediators involved in these type of cases. And that type of court assistance can also, I think, expedite the settlement of the dispute. A lot of the water disputes in the West have been solved by mediation, leading to congressional settlements, and it certainly is a more productive and satisfactory method of conflict resolution in many circumstances.
I'd like to add into that conversation about special masters. Here in New Mexico, we do have special masters, and they work with the Office of the State Engineer. I think part of the question was, can you get special masters to work with climate science? And the problem, at least here in New Mexico, is if you look at our water code, that's where the authority for special masters comes. It starts and stops with the water code. If you don't have climate science within your water code, you're not going to have special masters really working with climate science. But I have seen in our state that when the language allows the special master to consider water conservation, waste, and efficiency, sometimes you see the Office of State Engineer coming in and working the decision as if it was really a climate science, climate change type case. I think that makes sense. I think that's where we're going. But, as Judge Appleby's pointed out, John pointed out, we're really going to need to get our legislators to make these changes, because the function of a special master is legislative in nature.
Ah, okay. I didn't think about it that way. Okay. Thank you. One person was asking about if any of you have know anything about trends with respect to tribal treaty obligations and water law.
Let me just
Yeah.
jump in and say that is beyond my area of expertise, but I know that I need to get up to speed on that. And in the course outline that we have been developing for the online on demand, there will be that component, because I'm increasingly aware of how important that is. And so something on the to-do list.
I think, as many in our audience know, there is this doctrine of the federal reserve water right that can be asserted by Indian tribes as well as federal agencies. And it has been one of the basic reasons we've had these general stream adjudications, so that there can be a judicial quantification of the priority date and the quantity of those rights. We heard last week about the Colorado River, 30 Indian tribes, many of them asserting reserve rights. Probably 12 of those have totally unquantified, unrecognized rights. So there'll be a considerable amount of litigation or settlement activity in that basin, along with other Western basins.
Did you want to comment, Judge Arrieta?
Yeah, I don't have much to add other than I agree with what John said. A lot of these tribal compacts with federal government or treaties allow the Indian tribes to have priority dates from the date the reservations were established. And I know that there's been at least 2 to 3 cases in New Mexico where that has been the result. Litigation against Indian tribes, questions of right of appropriation, and most of the treaties go back to the late 1800s, early 1900s here in New Mexico. So they've got a very ripe and very early appropriation date for their water claims.
Okay, thanks. There are a couple of questions about mediation, which has come up a little bit so far. Do any of you have experience with court-directed mediation before trial dates? And particularly, have any of you encountered the John McCain National Center for Environmental Conflict Resolution in your work on water law issues?
I have not, but another thing that I've been thinking a lot about is how it would assist or facilitate mediated resolutions to have judges who are better trained in water law. So again, part of my pitch is that if judges have the expertise that they need, it will be more easy for them to make a credible assessment of a case and tell people, look, this is how I see it playing out.
Makes sense. John?
I am aware of this center. It was previously known, I believe, as the U.S. Center for Environmental Conflict Resolution, Tucson. They provided staff assistance to something called the Missouri River Recovery Implementation Committee, which was a broad-based stakeholder and sovereign group trying to make recommendations to federal agencies on endangered species recovery. And there was not a pending lawsuit at that time, but the states had gone through reams and reams of cases getting to that point. So the center's work was excellent in supporting a broad-based effort of conflict resolution.
Thanks. Here's another question, kind of stepping back to the broader context, and I think all of you may have something to say to this point, but what are the factors that influence the opportunity to develop specialized courts? Judge Appleby, you have the most recent and direct experience with it, but John has the historical and global perspective, and Judge Arrieta can also talk about the evolution from his state. So, you know, what are the political, what are the economic, what are the different kinds of factors that play into the development of these specialized courts?
Well, certainly for the online program, money is the really big thing. But what I will say is that I have been very heartened by the widespread enthusiasm for the project.
That's
and
interesting.
Yeah, and so I think everybody can see the need. And in a lot of ways, I regret not trying to bring forth this initiative earlier than I did, but in many ways, I think the time is right now, because everybody's aware of the issues. They may not have the expertise that some of the people on this panel have, but everybody can see the need. So I think that the obstacles may be fewer than I had imagined a couple of years ago.
That's a very interesting observation. John or Judge Arrieta?
I have maybe two. One is something that you and I talked about, is just this tension between local accountability of judges, which is preferred a lot by rural areas, and a specialized court that may be a little more distant, both legally and geographically. A second concern, I guess, as Judge Arrieta mentioned, his courts might evolve to handling a lot of different types of claims, including tort claims. And I'm wondering, how does the jury system fit into that? We might have specialized judges, but what about the jurors? How do we bring them up to speed? So those would be questions I would have.
I want to follow up with Judge Appleby's concern about funding, because I think that is a critical element or development in terms of putting together specialized courts. And I want to put in a plug for the old adage that I believe in, that if you build it, they will come. If we're able to put together, call it water court / climate science court, or just a climate science court, I think with all the developments that are occurring outside with climate science, with the droughts, hurricanes, so on and so forth, you're going to find a lot of legislators in all 50 states looking for answers. And if those legislators hear that the courts are doing something about this. They've got a specialized court that's established. We will probably get funding immediately or quickly from the legislators because they want the problem to be resolved. So rather than take time to do it through a special enactment, they'll go through the courts who've already got that specialized knowledge. So I'm a big proponent of setting up your drug courts, even if you have to do it by superintending control, not your drug courts, your water courts, climate science courts, and starting it off without legislative help. That being said, I think a component for the development of specialized courts that ranks up there with funding would be education. And we've talked about it here. There's a lot of education to be provided to the judges, to the legislators, and to the public in general of why we need water courts or climate science courts. And, you know, the problem is, as Judge Appleby pointed out, these quarterly meetings, you know, these type of things may not be sufficient. We need to have more training, more specialized training to educate our judges. And then lastly, I think an important component in developing these specialized court is establishing a structure. You know, how do you establish your water courts or your water structure? Do you have, like New Mexico, adjudications and administrative oversight, and then at the trial level, water judges? Or do you emphasize one more than the other? That all will depend on the on the states. Every state is unique. They may think, you know, we need to emphasize administrative side more than the courts, or vice versa. There's no one model structure and no one model water law structure. I think it all depends on what the states need. And, you know, I think those are three components for me, is funding, education, and structure. Thank you. Sandy, I can't hear
I
you.
just realized I muted myself. Sorry. Here's a specific question for Judge Appleby. Is there a website for the online course that's being developed, or has it not yet been established? Is there a way interested parties can become notified when it becomes available?
I'll say that we anticipate distributing a course outline or making it available. I'm not sure the mechanism for doing it. I'm not at all reluctant to share it. I would say we've got it sort of 95% there. Although based on some of the things that we heard at the conference last week, it's going to get bigger, not smaller. And I don't know, maybe John and I should discuss this with Joy at NJC, because it would be helpful to get feedback. And we are looking, for example, for expanded topics, but also potentially for subject matter experts. Dividing the waters will want to, you know, be the ultimate decider on the curriculum. But that doesn't mean it's not open to suggestions and feedback.
Great. I would mention that the Climate Judiciary Project is also developing a resource website with materials broader about climate change generally and courts, but certainly will be relevant for these questions as well. I have one last question that may primarily be for John, but what do any of you know about how lessons from specialized environmental courts, that some of which John mentioned in his remarks, have fed into the development of water courts, or vice versa? Just thinking about the converging sets of issues and where to draw lines between climate and water, and you know what the overlaps are and how to most efficiently use resources. I'm wondering if there is a communication and exchange going on between the water court world and the specialized environmental court world.
I don't have a good answer for that, Sandy, and maybe the conversation with Prings at University of Denver, they might have more information on that. But I think as Judge Arrieta mentioned earlier, to the extent that you address climate change, the role of drought and mega drought is an important, huge factor in all that.
Great. I think that covers all of the questions. So I want to thank you all very much. I'm really excited about this. I think we learned a lot today and a lot of issues were raised. But as we said from the beginning, we know this is an ongoing conversation. So we look forward to continuing working with you and learning how things are evolving in your states and to future discussions. I think Madison has a few closing remarks before we sign off. Muted.
There we go. Thank you. Hello, everybody. Thank you once again to our audience for joining us today and for your thought-provoking questions. We hope you will continue to think about the topics discussed today. If you have ideas for future programs, either discussing the topics from this webinar or other webinars, please feel free to contact me at calhoun@eli.org, calhoun@eli.org. We're grateful for your participation in today's webinar, and if you're not yet a member of ELI, I hope you'll consider joining us for future programming of this caliber. I want to extend a big thank you to our fantastic panel. Thank you to Sandy, John, Judge Arrieta, and Judge Appleby. You've raised key points today and prompted the conversation further, and we're so grateful that you took your time during this busy season to be here. So with that, I just want to tell everyone to have a great afternoon. Thank you.
Thank you all so much. Take care. Look forward
Thank
to
you.
being in touch in the future.
Thank you.
Bye.